Good afternoon, everyone. The Appellate Division First Department is now in session. Welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar, so please listen carefully. People versus Nareda Matthews for the appellant.
Appellate requests 5 and 2, please.
And that's Abigail Everett.
Abigail Everett, yes.
And for the respondent,
Good afternoon, Your Honor. John Hughes for the people.
that's 5 minutes.
Thank you.
Akura 4 versus Emirates Airlines submitted. Sophia M versus James M for the appellant.
It's Philip A. Greenberg, 5
and 1.
5
And
and
for
1.
the respondent,
Leah Ross for the respondent, 5 minutes, please.
5 minutes. Excuse me. Excuse me. People versus, thank you. People versus Araldito Lara Medina for the appellant.
Good afternoon. This is Amelia King Musa.
5 and 1 for the respondent.
Good afternoon, Andrew Seawald for the people.
5 minutes. Villager Capital versus Union Settlement is submitted. Strategic Funding versus Steenbach Incorporated is submitted. People versus Rudolph Brown for the appellant.
Good afternoon, Hunter Haney.
2 minutes. And for the respondent, we have a submission. People versus Luis Guzman for the appellant.
Good afternoon, Benjamin Rutkin-Becker.
6 and 2 for the respondent.
Good afternoon, Julia Gorski for the people.
6 minutes. People versus Ronald Smith is submitted. Zioli versus Jacobowitz for the appellant.
Douglas Shearer for the appellants, Your Honor. Good afternoon, 5 and 1.
Good afternoon, 5 and 1. For the respondent,
Good afternoon, Your Honor. Barbara Goldberg. I respectfully request 5 minutes.
5 minutes. People versus Daisy Rangel for the appellant.
Good afternoon. This is Amelia King Musa again.
5 and 1. And for the respondent,
Good afternoon, Valerie Figueredo for the people.
5 minutes. Gray versus the City of New York for the appellant.
Nolan Matz for the appellant, 5 and 1, Your Honor.
For the respondent, 5 and 1. For the respondent, is Julie Steiner here yet? I know
She did not appear at the first calendar call, Your Honor.
Okay, I just have one more case, but I'll call it and then go right back. Vasquez versus RXR Realty, LLC for the appellant.
Anthony DiStefano for the appellant, Your Honor.
6 and 2, and for the respondent?
Chris Simone for the respondent.
And there are 2 appeals on this case. Okay, back to Gray versus the City of New York. I'm going to give Ms. Steiner one more opportunity. Anything? And Ms. Steiner? Okay, well, sometimes people have technical difficulties, so if she appears, it's 5 minutes. If she does not, it's a submission. And obviously, if she doesn't appear and then it's a submission, I'll reduce your time because you won't need 5 and 1. Okay. Council, please remember, as always, that we have your briefs, we have your record, we are fully familiar with the facts of your case, so please go directly to the points that you wish to make. Also, as is customary, please don't speak when a justice is speaking. That's particularly important during our virtual argument so that we can hear one another and so that you can hear the question that's being asked. And finally, please keep your mics muted until your case is called. And then only when you're the person speaking. And of course, try to remember to unmute them. Thank you for your patience and cooperation. The first case on today's calendar is People versus Narada Matthews.
Good afternoon,
And
Your
just give
Honor.
me one moment before you begin. Okay. Ms. Everett, okay.
Good afternoon, Your Honor. Abigail Everett for Appellate Narada Matthews. A significant part of the people's case here was rested on brief excerpts of recorded phone calls made from Rikers Island. And we had about 2,000 phone calls, I believe, and out of this, the people introduced what the jurors in their later question referred to as snippets of calls. And the defense asked the court to permit the defense to admit a few extra portions of these calls, which we submit were important for the jury to consider the defense in its fullness. For example, the DA's position on summation to the jury was that these short statements by Mr. Matthews represented admissions on his part. But the defense called an expert witness who testified regarding Mr. Matthews. He was beaten very severely at the time of this event. He was in a coma. And if you look at the underlying portions of the various calls that I highlighted in my brief, you will see that there are a number of instances where Mr. Matthews says, my man D told me this, and then he goes into a discussion of what happened during the time of the event, or my little bro told me this.
With regard, yeah, sorry to interrupt you, but with regard to those calls and the doctor who testified, I think that with regard to Dr. Barry Jordan, the testimony was that he couldn't introduce any additional statements that weren't already in evidence, but he was able to speak freely about those statements that were in evidence, and I think also made a statement that sort of summed up the defendant's mindset, if you will, without actually, making reference to the other statement. So with regard to the doctor, wasn't that fairly complete? I mean, didn't it allow him to fairly completely give his testimony?
Well, if the judge had permitted the defense to put in additional statements, which they asked to put in before the trial even got to the point of litigating the doctor's testimony, then, the doctor testified that individuals with traumatic brain injury often listen to what various people tell them, and they kind of reconstruct their understanding of what happened based on what other people told them. And in fact, these statements in the recorded calls were independently admissible for the defense because, first of all, the DA was arguing these were admissions. And whenever you have a statement that could be viewed as an admission, you're always allowed to bring in that the defendant also said in the same conversation statements which are denials of guilt. So you've got that. You've also got the fact that the judge had ruled pre-trial that it was a jury question whether or not these were knowing admissions on the part of the defendant or whether he was repeating things. And to support that defense, which Appellate had a constitutional right to do, he should have been allowed to bring out additional portions of these crimes that really put into context the small snippets that the DA was bringing out and asking. In the summation, the DA said, look, there's no question here. The defendant cannot deny that he's admitted this crime. This was a key part of the defense. I also briefly would like to touch on the fact that the court kept out 2 911 calls that the defense proffered. Now, the court below saw this as basically 2 separate events, and the judge ruled that the 911 calls really were only relevant to the second part of the offense where Appellate was beaten into a coma and shot. But I think that if you consider the defense, which was that the complainant and his brother were not telling the truth and had a motive to lie about what happened. The statement, for example, of the woman in the passing cab was she saw 16 to 20 people beating somebody to death. Now, the 2 complainants testified that it was either 5 or 8. It was a much larger event, and that gave the jurors, should have given the jurors a sense of the motive of these people to cover up their wrongdoing. And also, since the DA never prosecuted.
But wouldn't it not have been having those statements come in for the truth of the matter asserted? This was a woman who had no involvement with it. She was passing in a cab, and I don't even think they have her name or anything. So they don't have, it was just the statement. It wasn't reliable.
Well, Your Honor,
and by the way, was this preserved? Was this issue preserved? I don't think it was.
The request to admit the 911 call of the woman in the cab, certainly the defense requested it, and the judge ruled on it below. And in addition, there was a request to admit the spontaneous statement of the man in the windows looking down and seeing various people picking up spent shells. Again, right. This was a contemporaneous observation of the people who shot Mr. Matthews acting in a way to cover up their guilt. Again, this shows their bias to fabricate at the trial. Bias is never.
But counsel, did they tell the police officers that they actually beat up Mr. Matthews and that someone, they didn't say who exactly, but somebody shot him? So they were not trying to cover up that Mr. Matthews was not beat up by a crowd. And the statements from that man, he said it looked as if he was not certain that they were doing exactly that, picking up shells from the floor.
I mean, I think that these statements of both the woman in the cab and the man looking out the window are contemporaneous statements of what they're observing at the time. They were sufficiently reliable for the jurors to be able to assess what was going on. I will point out that the people had a police officer testify as to the location of all the shells that were recovered, and yet they keep out the contemporaneous observation by an eyewitness that some of the shells were removed from the scene of the crime. So a lot of these things go towards issues that the prosecution is seeking to establish with the jurors. And yet,
this is Justice Kennedy. Can you tell me how these 911 calls were even relevant to the material issues at the trial? Because really what the jury had to decide is whether or not defendant shot Butler, and they concluded he did. So what's the relevance here?
Well, I ask Your Honor to consider that these show bias on the part of the complainants, that they're trying to really to convince the police and the people that they are basically the victims of this crime. They're not being prosecuted. Bias to falsify is never collateral. It's not just a question of whether this goes to their credibility. The judge said, well, you already got to impeach their credibility. You have this photo of the complainant with the shooter of Mr. Matthews. And so you can see that there's a potential falsehood, that he said he didn't know this person. But it wasn't just this instance. The defense had a right to establish that they had a motive to falsify in a number of regards to this event. And in fact, it seems that what happened pretty early in this case was the police made a determination who was the most responsible for what had happened, and didn't prosecute the complainant and his brothers for a very serious assault on Mr. Matthews.
But counsel, once you put it all together, and you take into account the recorded conversations from Rikers, where he's actually talking about having committed this offense, right? Is it really relevant that somebody saw a group of people beating up on Mr. Matthews, and that someone may have seen someone else picking up shells from the floor? He himself told his friends on the phone, and it was recorded, that he did this offense, that he committed it, and how he did it.
Well, Your Honor, I think that gets to the very point I'm trying to make, is that one, the expert witness said that it's extremely unlikely that a person who suffered the kind of head trauma, who was also intoxicated, that Mr. Matthews suffered, really remembered what happened, and that these purported admissions that we're talking about right now are not actually admissions. They're no more than neighborhood gossip about what happened. And the other thing is, there are also statements in these precluded calls that really go against what the complainants are saying. They talk about.
And what about the conversation he had with somebody? It says a man, where he was being coached as to what to say if he were to come to trial. What about that?
Well, first of all, since Mr. Matthews didn't testify, those statements weren't relevant to his credibility. But if you can see, in some ways, the fact that he's so open during that undercuts the people's argument that these calls about him not remembering and people having to tell him were staged because Mr. Matthews knew that these were recorded calls. And yet some of the things he said about the video, where he admits that he can be seen on the video. And by the way, I would ask your honors, if you haven't already, to take a look at the video, because you'll see how little it really documents what happened in this event and underscores that the people's case really relies solely on the credibility of the complainant and his brother, both of whom
Thank you, Ms. Everett. I've given you a lot of extra time. You'll have some rebuttal.
Thank you.
Mr. Hughes?
Good afternoon, Your Honors. John Hughes for the people. I'd like to go ahead and start where my adversary left off with the 911 calls. First of all, to your question, Justice Renwick, I believe the defense did seek to have the 911 calls admitted. However, they did not raise any constitutional arguments. Yeah.
I understand. I understand that, but there is significance to precluding this. I mean, it sort of completes his whole defense here, which is that I was the one who was attacked. I was the victim. And these 911 calls at least gives credibility to that defense. And by, sort of carving them out, he loses that opportunity, doesn't he?
I don't think so here, Your Honor, and there's a couple of reasons for that. First of all, these 911 calls really only pertain to events that came after the alleged crime, after Butler had already been shot. And really
I think both people were shot and people were on top of him. I think that's what, right? The 911 call referred at least to the woman who was talking about him being beaten up, and then the person who sees people picking something up from the ground.
That's correct. And but really, at the end of the day, these are all undisputed issues because, the victim admitted, yes, after, the defendant shot me, my friends and I, we beat him up. It was, undisputed that someone who was at the same party as the victim also shot the defendant in the leg again afterwards. And so at the end of the day, these weren't really things that the victims were denying. So all things
except that it's coming from the victim, the victim who we're calling the victim versus the defendant, and that evidence would come in on behalf of the defendant, not on behalf of the victim. And I think the difference was the number of people, which would have gone to show that the victim was downplaying the number. It wasn't fact, but the jury would have been able to weigh it. It went to the weight, not to the admissibility.
Well,
so
I think
doesn't that take away from the defendant's ability to defend himself, to proffer a defense?
Well, I think the court still had discretion to decide whether this hearsay was actually reliable or not. And I think for some of the reasons that Your Honors pointed out, there were really serious reliability concerns here. First of all, the taxi passenger was, her statements were internally inconsistent about how many people we're talking about. And also on the surveillance video, you can actually see how many people are running from the gathering, off screen to where defendant was beaten up. And, just watching it, you can count. There's only about 9 of them. So the fact that the taxi passenger is moving by a moving vehicle, so it's hard to see how she could possibly have a good look at this. And, first she says at least 16 people, then she says at least 20 people. The number sort of keeps going up and seems completely contradicted by what we can actually see on the video. And, and given that this obviously was a very fast moving situation, I think the victim and his brother, they tried to give their estimates of how many people were actually taking part in that assault after the fact. But at the end of the day, they admitted to the important facts, which is that there was a group of them and they beat up the defendant afterwards. And just very quickly, I would like to touch on the expert witness issue as well. I would just point out the defense expert here was able to say that he listened to defendant's Riker's calls and he expressed a very clear opinion about, after listening to these calls, defendant said he did not have a memory of a shooting, and the defense expert even opined that the Riker's calls did not establish that defendant remembered any part of the shooting. And this is one of many pieces of evidence that the defense had in order to make this sort of memory loss argument, as I call it, which then they were able to make on summation as well. I think if you look at, I believe, 566, 567, the trial transcript, you see the defense relying on the admitted parts of the Riker's calls and relying on their own expert testimony to be able to raise this memory loss argument.
We see so often, it's the doctrine of completeness. That's why evidence is allowed to come in. Why isn't the doctrine of completeness relied on in this instance where he's making all of these Riker's calls? Often we see Riker's calls going in all the time. And certainly he's making these statements quite openly. Why wasn't it appropriate here to allow the defense to make, again, proffer a defense by having the statements put in?
Well, at the end of the day, I don't think that these additional excerpts the defense wanted to have admitted really shed any light on the other parts of his calls, the admitted portions where he made certain admissions.
But that was, if you think it didn't go, it didn't matter which way it went. Why didn't it go in favor of the defendant who was trying to put on his defense?
Well, in the first place, this is all unadulterated, self-serving hearsay, in many cases double hearsay. So it's important to remember that I think that there's the presumption that this is all inadmissible. And, and this isn't supposed to be just a conduit for a defendant to be able to testify without actually taking a stand. For the rule of completeness to apply, these extra portions would actually, they would need to explain things and clarify things. And here, if anything, I think the excerpts tended to do the opposite because of how just vague and ambiguous in many cases they were. But more fundamentally, the mere fact that defendant was just talking to third parties about his case, that doesn't mean he doesn't remember what happened, and it doesn't undermine his admissions in the other parts of the calls. So here, Justice Merchan did not exclude any portions where defendant is saying something like, "Oh no, I don't remember a thing." That's not what's in these excluded portions. Really, at bottom, defendant is just relating neighborhood gossip. For example, in one of these excluded portions, he's saying, "Oh, I heard that this woman, Aunt Pauline, was trying to call me that night." Sure, as many defendants do, he's trying to learn, maybe he's asking about neighborhood gossip, what are people saying about this? But that doesn't mean he doesn't remember it. And I think this might be a different case if some of these excluded portions actually showed him saying things like, I don't remember a thing that happened. But that's really not what we're talking about here. And I see that about 5 minutes is up. So unless the court has any other questions, we'll rest on our brief and ask that you affirm.
Thank you.
Thank you.
Ms. Everett, we're back to you.
Just briefly, the last point about, it might have been admissible if he had said explicitly more often, I don't remember what happened. Well, these are real life conversations with people, and the defendant was allowed to bring out the nature of a conversation as it happens. And in context, you can see that he's saying, my man D told me this, little brother told me this, this is the way people talk. Also, I would submit on the whole question of the 911 call regarding the woman in the cab. It's not at all clear that the number of people we see on the video running towards the defendant is the number of people that were involved in the shooting. That just happens to be the people who ran by that one surveillance camera. So I don't think we could infer that that is documented proof that only 9 people were involved. And the other thing is, while the complainant and his brother talked in terms of 5 or 8 people, this woman, who we don't know that the cab wasn't stopped, she was looking out the window, she sees 16 to 20. That is a significantly larger attack than what the complainant and his brother are describing. So yes, they did admit that they hit the defendant, they were punching him, but they did not, arguably, defendant was allowed to establish that they were downplaying the seriousness of their acts.
So, separate, in other words, the admissibility, you wanted to admit those statements, have those statements admitted to test whether or not the complainant and his brother were being truthful, correct?
And whether they were not being truthful about inculpatory criminal acts, that they had a reason to want to cover up the extent of what they were involved in and to show bias. I think that the point I would like to leave you with is that bias is not collateral. It's not just their credibility. If I could have just half a second to say that the excessive sentence point is fully briefed, but I would ask your honors to think about whether this is an instance where 25 years to life is really an appropriate exercise of discretion, given how seriously Mr. Matthews was beaten and the very serious nature of even the minimum sentence of 20 to life. And I would ask you to reduce that as an exercise of your discretion. Thank you.
Thank you. Thank you both.
Thank you.
Next case is matter of Sophia M. versus James M.
Yes, thank you. Philip Greenberg, attorney for James M. Appellant. In this case, the only thing that Mr. M allegedly did that they say constituted a family offense was writing to friends, families, and colleagues about
I don't think that that's just it. I think it's writing to friends and colleagues. He has he has the right to express himself. I think it's the fact that he copied her or shared, either copied her on the letter or shared with her that he was sending it to friends and colleagues, knowing that that very thing upset her, that was part of her underlying anxiety and everything else. That's really what the issue was about.
Well, except that she admitted on cross-examination that she never told her father to stop sending this. So when they say it upset her, the first time that he hears...
Didn't the court, wasn't this already before these issues had already been raised, where he knew that he wasn't supposed to be sending these things to her?
No,
whether she said it or not? No,
it was before Justice Drager, where and bear in mind, this is really a spin-off or a follow-up to the divorce of the parents, and Justice Drager denied the relief requested by Mr. M's ex-wife, among other things, saying that what was being asked for actually impacted upon his protected First Amendment rights. And after that was denied, then she had their daughter bring this petition in family court. And I remind the court that it wasn't even disguised that the ex-wife was promoting this after having failed in Supreme Court, because included with Miss M's petition is an affidavit from Mr. M's ex-wife supporting the
Mr.
petition.
Greenberg, this is Justice Kennedy.
Yes.
But didn't Judge Drager warn the appellant that, when she learned of certain emails that he had sent to third parties regarding Sophia, that if he engaged in such conduct in the future, that he may be subject to criminal charges for aggravated harassment? I know you said that in your brief that Judge Drager gave permission, but I'm not sure that's accurate.
Well, she didn't use the word permission, but she did warn him that certain actions, not those alleged before her, could rise to criminal actions. But she did not say that anything that he had done, that he allegedly had done, was.
But that's because with regard to what he had done, I believe at the time, was express his opinions to other family members. He's still permitted to do that. It was what he, in this occasion, sent to the daughter, that it was also relayed to other family members, but now it was going to the daughter to show her what he had shared, and also to tell her mother was whatever negative statements he made about her mother.
Right. What you'll see from the record is it's the same letters, and the daughter had been copied on those, and Justice Drager does not suggest that the daughter would have a claim. And if in each and every one of the family offense cases, which involves correspondence or communications far, far more serious than this, the courts heavily took into account whether or not the purported victim had requested them to stop. In some of the cases cited by the other side.
But Mr. Greenberg, this is Justice Kennedy again. I mean, certainly the appellant was aware because of past history that sending these emails would be upsetting to her, and he did it anyway.
That's actually not it at all. As a matter of fact, from his testimony and the fact that the daughter never told him to stop, and he indicated that he would have stopped if his daughter had told him to stop. But there was no.
But that was my question. Right. What I'm saying is that the appellant was aware that sending these emails would upset her, and he did it anyway, to over 130 people.
He was not aware that they would upset him.
Counsel, this is Judge Scarpullo. You mean to tell me that the daughter blocks him? She literally blocks him, and you think it's credible? She blocks him from sending anything to her after he sends this text, and you think it's credible for him to say he had no idea that she was upset?
Actually, she didn't block him until after he had made it clear that he would not.
Let's just say once she blocked him,
he stopped communicating with her.
No, I don't think that's right? He blocked him in January, and then in June, he sends around an email, 6 months later, he sends around an email to several people, including her, disclosing that she takes medication and something that he's not entitled to disclose, and also that her grades are being artificially enhanced and that there are long-term side effects by the medication she's taking. That's 6 months after she blocks him.
Right.
And it's your position that he's got no idea that disclosing her medical condition, disclosing that she takes medication, accusing her of having false grades because of the medication. Your testimony is, and after she blocks him, that he has no idea that this is going to upset her.
Well, he didn't say she had false grades, and the medication.
I think what he said was that she was taking academic enhancing drugs. That's what it said in the email. So let's not quibble. Sure. Let's talk about whether you think it's credible to sit here and argue that he had no idea under those circumstances that this would be upsetting to her.
Yes, Your Honor. He was expressing his opinion. She knew that he was always opposed to it. She testified that she resented his being opposed to her, quote, taking the good grade pill so that she could enhance her grades. He never said that her grades were poor. In fact, it was just the opposite. He said that she was a good student before.
Thank you. You have rebuttal. Ms. Ross, I believe. Is the respondent here on matter of Sophia?
I apologize. I
okay.
need to unmute. Good afternoon, Your Honors. A couple of things that I do want to...
Your appearance, please.
Leah Ross, Ross Law PLLC for the respondent.
Thank you.
A couple of things I'd like to clarify that Mr. Greenberg raised this afternoon. The issue that was brought before Judge Drager, those were a completely different set of facts than what was brought in front of the family.
How are they different? Mr. Greenberg says that they were the same emails, the same letters, the same everything.
The decision from Judge Drager is from April of 2017. The allegations in this case are a series of emails that were sent from May 4th, 2017 to, I believe, June 23rd to 7th.
I understand the dates are different, no question. What about the content?
The content, Your Honors, I because I did not represent the mother in that action, I do not have those emails. However, that they were sent to the daughter, and the content actually is different, which we know because there was specifically the email sent on her graduation day, which was after the April 27th decision. There was specifically the email sent on May 4th, which actually brings up and identifies the mother's birthday as May 4th, which again is after April 27th. And there's also specifically the email that was sent on Father's Day, which is after the May 27th date. So we know at a very minimum, those emails were sent after the appellant was warned by Judge Strager to cease his behavior. Plus, the relief that was sought in that action was injunctive relief by the mother. It was a completely separate action than what was brought here. When he continued the behavior, and remember, this is not an isolated incident that happened in a vacuum. This is an estranged relationship that started when this young woman was a young child.
Yes, we're aware of the facts. Let's stick to the letters that we're talking about and emails.
Now, moving on to the request for the father to stop, I would submit that Ms. N made it very clear to the father in the text messages, in fact, in the last text message that she sent to him, that if he didn't change his behavior, that she wasn't going to continue a relationship with him. And after that, she did not send any further correspondence to him, and she did block him. Yet he continued to contact her anyway, and then when he didn't get a response is when he started with sending the emails to her and to, as I have made clear, at least 130 individuals. The lower court properly found by preponderance of the evidence that the appellant committed these family offenses. The factual issues and the credibility of the witnesses was determined by the lower court and should not be disturbed. His intent was very clear. He knew that, and he admits on cross-examination that he knew that these were sensitive issues to the complainant, and that these were going to upset her, that these were private details, and he also knew from the custody agreement that he had signed 2.5 years earlier that the complainant didn't want any photographs of her disseminated, that she didn't want any contact. It was he was all very much aware of this behavior, yet he continued it throughout until, as he admittedly says, he didn't stop until the court told him to do so, which shows us that he had intended on continuing to proceed until such time that the court issued the order of protection in June of 2013. The substance of the emails have absolutely no legitimate purpose. They're attacks upon her family on very sensitive issues, and any attempts by the respondent, the appellant, to claim that they were legitimate or merely just updating families and friends is completely disingenuous. Are
there any other questions from the panel? Thank you. Mr. Greenberg, we're back to you.
Yes, I'll just use the 1 minute very quick.
You've muted yourself, sir.
You went the wrong way.
Opposite. Okay. Are we okay now?
Yes.
Okay. So yes, the custody agreement said that he couldn't communicate with her. So she's the one who reinitiated the communication. That's undisputed. In fact, they put in the text messages, and it was her testimony that she reconnected the text message where she said something along the lines, if you don't have your change your behavior, in no way related to any of these emails. And finally, I just remind the court that the temporary order of protection was in place for over 2 years. Referee Adams added another 2 years. And if you look at the precedents, even if this were, and of course we dispute that it was a family offense, the order of protection period is far in excess of actions much more serious, and that includes appellate cases. So if there are no further questions, I thank you for your attention.
Thank you. Thank you both.
Thank you.
People versus Eraldito Lara Medina.
Good afternoon, and may it please the court. My name is Amelia King-Musa, and I represent Mr. Lara Medina. The court below improperly denied Mr. Lara Medina's speedy trial motion. The 42-day period at issue on appeal went far beyond a reasonable time needed by the prosecution to prepare for a suppression hearing. This was a straightforward case involving a single isolated incident of assault. Nothing in the record indicates that there were evidentiary complications or peculiarities that necessitated well over a month of time to prepare for a hearing. Now, the prosecution is currently charged with 179 days, and typically this court has found that 2 to 3 weeks is appropriate to prepare for a trial.
But we haven't found, go ahead, Judge. Go ahead.
I just wanted I wanted you to address the fact that he waived the right to make the speedy trial issue, raise the speedy trial issue on appeal, correct?
No, Your Honor.
He signed a written waiver, right? And that waiver included this right, and he waived it. So why are we having this discussion?
There was a written waiver in this case, but the mere existence of a written appeal waiver cannot cure any defects in the oral colloquy, and there certainly were defects in the oral colloquy. The Court of Appeals and People v. Bisona have recently said that, written waivers really have to be looked at in the totality of the circumstances. And here the purported appeal waiver is absolutely invalid. First of all, the appeal waiver wasn't even elicited until Mr. Lara Medina had already admitted guilt. And even at that point, the waiver misinformed Mr. Lara Medina of the actual rights that he was waiving. The court stated that Mr. Lara Medina was waiving the right to appeal any decision made by a trial court,
So the timing here was unorthodox, for sure.
Yes.
But it was, the prosecutor mentioned that the waiver existed and brought it to the attention of the court before, I think it was after the defendant had allocuted, but before the court had accepted the plea. So to that extent, it was not untimely in a way that, would create a problem. And the waiver itself was in writing and was, the court did ask about it and the defendant did sign it. So we have a waiver. There might be some questions in the allocution, in the waiver, in the review of the waiver stated by the judge, but we have a written waiver that's accurate.
Correct, Your Honor. But again, I return to this totality of the circumstances test. There was a written waiver, but there's actually no indication in the record that Mr. Lara Medina understood or read the waiver. The court below never explained the contents of the written waiver. It was only counsel.
Counsel, this is Judge Scarpula. Didn't the defendant say on the record that he understood the waiver?
I do not, excuse me, 1 second.
I think he
said
did.
That he had.
He said he discussed it with his lawyer and he understood it.
Not believe that is for the written waiver. The court never addressed his understanding of the written waiver and his counsel's explanation of the written waiver until after it was already signed.
But he did state on the record that he had discussed it with his lawyer, he understood it, and he agreed with it.
Yes, this was never expressed at all until after Mr. Lara Medina had signed the waiver. And inquiry here was particularly important because Mr. Lara Medina, this was his first known arrest in New York State and his first contact with the New York justice system. And the written waiver itself, again, does not automatically cure these real deficiencies in the oral colloquy. The court never made clear to Mr. Lara Medina that, he was waiving rights by signing this that were not automatically waived by pleading guilty. Again, Mr. Lara Medina was 19 years old. This was his first ever contact with the New York criminal justice system, so inquiry was particularly important here. And going back to the speedy trial motion itself, as I said, over a month and a half of time is much more, goes beyond a reasonable amount of time that the prosecution has or needs to prepare for a suppression hearing. So this court has found up to 34 days to be reasonable in analogous situations. And we ask that the court so find here. But however, even if the court feels it cannot make that determination on the record, a simple solution is to remand this case to the trial court to have a hearing to determine how many days would have been reasonable.
Counsel, if I may, Justice
Yes.
Kennedy here, what's the factual issue that even warrants a hearing here? What's the factual issue?
So defense counsel raised multiple days that it believed, or multiple periods of time that it believed should not be counted. And a factual issue here right now is how many days were reasonably needed for the prosecution to prepare for a hearing itself. If this court finds on the record that it cannot state how many days would be reasonable, then that in itself is a dispute of fact that necessitates a hearing, which defense counsel asked for multiple times.
Thank you.
Thank you.
Mr. Seawald, I believe.
Good afternoon, Your Honors. Andrew Seawald for the people. Your Honors, I would start by arguing that the right to appeal, the 30-30 denial in this case, was forfeited by the defendant's guilty plea. This court has not squarely examined the question of whether the speedy trial amendments that have made the right to appeal from a speedy trial denial not automatically waived anymore by a guilty plea, or not automatically forfeited by a guilty plea. This court has not considered that question squarely. The third department in People versus Duggins did consider that question squarely and analyzed the statute itself and concluded that that it did not apply retroactively to judgments that were final prior to the effective date of the amendment, which was January 1st of 2020. That was after the judgment in this case, which was February 28th of 2019. And I would just point out that since the Duggins decision was decided, the Court of Appeals denied leave to appeal on that particular case. That was on March 29th of 2021. And so I would just urge the court to look at the Duggins decision and to follow the reasoning of the third department in analyzing the question of whether the speedy trial amendment is retroactive and conclude that it is not. The legislature could have made the statute retroactive, or it could have made the amendment effective immediately as of the date that it was enacted and signed, but the legislature chose not to do that. The legislature chose to set a date of January 1st, 2020, which was 8 months after the amendment was passed, as the effective date for the amendment. And so if the amendment itself is not applicable to the defendant's claim, as I urge the court to find, then it wouldn't even matter whether the defendant validly waived the right to appeal the speedy trial decision. Any appeal of that speedy trial decision was automatically forfeited by the defendant's guilty plea. But as an alternative argument, I would also agree with some of the statements that the judges have made about the record regarding the waiver itself and the court's discussion of that waiver with the defendant. The fact that the written waiver was a thorough and accurate description of the waiver of appeal itself. And I would also point out that even though the judge during the plea colloquy did not seem to have heard the prosecutor at the beginning of the proceeding, when the prosecutor mentioned that the appellate waiver was part of the plea, the defendant seems to have heard that, and the waiver itself was in any event addressed before the plea was actually entered. And it was not as if the defendant had expressed some sort of surprise that all of a sudden the waiver of appeal was being mentioned before the plea was entered. And then finally, even on to address the merits of the defendant's speedy trial claim itself, a 42-day period following a decision on a defendant's suppression motion, which in this case included a motion to suppress statements, identification testimony, and physical evidence, is well within the range of reasonableness that this court and courts all around the state and the Court of Appeals have upheld as reasonable periods for the people to prepare for a hearing and trial following a decision on a defendant's motion. It was not an extraordinarily lengthy period. It may have been longer than some periods that the court has approved, but it is also shorter than other periods that the court has also approved as reasonable. It was within the range of reasonableness, and so the court's decision that in this case that 42-day period was a reasonable period for the people to prepare and thus was excludable was a correct decision, and there's no reason for the court to review it. Thank you, Your Honors. If there are no questions, I rely on my brief.
Okay, we're back to Ms. King-Musa.
Yes, thank you. To address counsel's first point, this court has already acknowledged the applicability of these new 3030 rules to cases which were pending on appeal as of the effective date of the statute. As counsel himself acknowledges, he's relying on a third department case, which is non-binding. And for the first department has already, issued decisions in People v. Person and People v. Acosta, which acknowledge the applicability of these newly amended rules. And then briefly turning to the appeal waiver, looking at the transcript itself to answer a previous question, the only question that the court asked the defendant about the written waiver was, have you signed it? And defendant answered yes. And one last thing to mention is counsel said that defendant never made any surprise when an appeal waiver was mentioned after he had admitted guilt, but defense counsel had and did indeed say, oh, I did not discuss it. And I believe that is on page 7 of the plea proceedings. And if there are no further questions, thank you.
Thank you. Thank you both. People versus Rudolph Brown.
Good afternoon, Your Honors. Hunter Haney for Appellant Rudolph Brown. May I begin?
Yes.
Thank you. This court should reduce Mr. Brown's sentence in the interest of justice. Mr. Brown is a 55-year-old man who has spent much of his life struggling with addiction. The maximum sentence imposed here for breaking into a deli was excessive, and especially so given that Mr. Brown is now battling terminal cancer, among other health conditions. His sentence should be reduced at least in a manner that is consistent with the plea court's erroneous promise of 391 days jail time credit, which indisputably cannot be legally fulfilled. A mere 1 year.
I have a question. This is Justice Kennedy. I know you make the argument about the incorrect promise about jail time credit, but doesn't that go more toward the voluntariness of the plea as opposed to the appeal waiver? Because you didn't move to vacate the plea, right?
It may very well be a basis for plea withdrawal, but this court also possesses broad authority to reduce a sentence when the interests of justice require it. And as this court recognized as recently as a couple of weeks ago in People versus Jennings, the supplemental authority that we submitted for the court's review, where the parties are under a misimpression regarding the available sentence, correcting the sentence to be consistent with that is an entirely appropriate and really fair use of this court's interest of justice authority. As a practical matter, too, given Mr. Brown's condition, he may not have enough days to risk disrupting his treatment. He proceeds daily, leaves his facility daily to receive stem cell treatments and has to drive 2 hours to Westchester Medical Center to treat his cancer. He may not have the ability, as a practical matter, to engage in repeated trial court appearances that would become necessary with plea withdrawal. So in light of his really unique circumstances, we would ask the court to exercise its discretion, and even ordering a 1 year reduction in this case, which is still a mid-range sentence, would make Mr. Brown immediately parole eligible and at least give him the chance, subject, of course, to the parole board's discretion, to pursue the best treatment options possible and to say goodbye to his loved ones in person.
Can you remind me where in this, where in the record there's evidence of his medical condition?
There's no evidence in the record of his medical condition, but we've asked the court to take judicial notice of the habeas proceeding that we filed on behalf of Mr. Brown in light of the emergency circumstances. As this court has recognized on at least a handful of occasions cited at page 4 of our reply, in light of the unique health crisis that many of the state's incarcerated population has faced over the last year during the COVID-19 pandemic, consideration of post-sentencing facts are warranted in a case where a defendant like Mr. Brown suffers truly acute health ailments that dramatically alter the scope of the contemplated punishment.
Our ability to do it is not my question. It's the extent of the issue, being able to examine the extent of the medical condition is what I was speaking to.
We've offered, and I would be happy to submit, if Your Honor would like, a copy of the habeas petition, which includes his medical records to consider. But Mr. Brown was diagnosed with multiple myeloma approximately 2 years ago and has been receiving daily stem cell treatments. He leaves the facility almost daily to receive treatment and is currently undergoing chemotherapy. And so, in light of those circumstances and in light of the fact that this offense is clearly a product of prolonged homelessness and addiction, and the fact that the court, what is certainly in the record is the court made this erroneous 390-day jail time credit promise, we would ask the court to at least reduce the sentence to a 2.5 to 5 year sentence.
Thank you. Are there any questions? Any further questions? No. Thank you.
I have one. When is he up for parole, counsel?
Currently, under the present 3.5 to 7 year sentence, he would be eligible to go before the parole board in May of 2022. So a mere reduction to 2.5 to 5 would make him immediately eligible to go before the parole board.
Okay.
Thank you, Your Honors.
Thank you. People versus Luis Guzman.
Good afternoon. Benjamin Rutkin-Becker on behalf of Luis Guzman. May it please the court. Mr. Guzman's forcible touching conviction was against the weight of the evidence. To begin, the judge below independently expressed his reasonable doubt as to the events underlying Mr. Guzman's conviction. Furthermore, Mr. Guzman's acquittal on the sex abuse count reflected the jury's rejection of the bulk of the complainant's account. The complainant testified to one rapidly escalating encounter that encompassed both sex abuse and forcible touching charges. Mr. Guzman did not contest that, if believed, her narrative established his guilt of each of them. He simply asked the jury to determine that her testimony as a whole was not credible enough to prove his guilt beyond a reasonable doubt. That's what the jury found here. And I acknowledge that none of us were in the deliberation room. However, one thing is abundantly clear from the record, and that's that the jury struggled mightily to decide this case. The jury deliberated here for longer than the short trial over the simple question that was really presented, again, about credibility. And
Counsel, this is Judge Mendez. You said, correctly so, none of us were in the jury deliberating room. So we don't know exactly what the jury was thinking when it decided to acquit on one and convict on another. Whether or not they simply didn't believe the complainant or they were exercising mercy for the defendant. Do we know that?
No, Your Honor, we don't know for sure. However, the most reasonable inference based on the record below and based on the way this case was presented is that this was a credibility determination. There's three things we know about the record. One is that, again, as I've mentioned, Mr. Guzman did not make any elements-based challenges. Two, unlike a case, for example, with a lesser included, sometimes there might be a case where the evidence really does seem to reasonably support a top charge and a jury convicts on a lesser included. In that case, there's a strong inference that the jury was just exercising leniency. But here, the way the case was presented, and it's notable that the prosecution actually shifts their theory of the case on appeal. But below, the prosecution argued that the forcible touching and sex abuse conduct was actually separate conduct in the same incident. The complainant's credibility went equally to both. However, the jury was really asked to determine whether he committed each of this separate conduct. The forcible touching was just the initial purported contact that Mr. Guzman made, and the sex abuse related.
So this is Justice Kennedy. Can you tell me why wasn't the jury free to resolve any contradictions and just credit the complainant's testimony? Why wasn't the jury free to do that?
So it does seem that the jury did not, in fact, credit the complainant here because Mr. Guzman did not contest that there was anything but credibility at issue and didn't make a specific challenge to the sex abuse charge. So there's really no reasonable explanation for why the jury could have convicted on one and acquitted on the other. Regardless of how Your Honors view the acquittal here, again, one thing that's absolutely clear is the jury's struggles. And it's worth noting that one of the first things the jury did here when deliberating was asked for a readback in full of the testimony of Mr. Guzman and the complainant, the two individuals who were actually able to say what did or did not happen in the locker room. Now, after doing so, the jury sent multiple notes to the court relaying that they were in a deadlock. They referred to themselves as a high integrity jury set in their beliefs. And
so it sounds like you keep making the argument that Justice Mendez spoke about before. It is a credibility decision. What you keep saying is the jury really considered these issues, really spent time weighing these issues. And in the end, they acquitted on the more serious charge, and there was jury nullification on the second charge. Perhaps, we don't know, but what's the legal basis for us overturning this case where you keep talking about how thoroughly the jury listened to the evidence?
Well, in fact, Your Honor, it seems that the jury, what actually happened is that the jury might have resolved any ties in credibility in favor of the prosecution. And weight of the evidence review is a critical bulwark in such a case because, again, the jury, after having a readback of both of the testimony, was at a deadlock. And only after requesting a readback of the testimony of three witnesses who were not present, somehow came to the guilty verdict. after they had already, there was a partial verdict taken and they had already actually acquitted on the top charge at that point. Furthermore, in our brief, we have detailed the myriad ways in which the complainant's narrative simply did not add up. It did not add up in the same manner as to both charges, and therefore reversal and dismissal should be ordered here. If there are no, sorry.
Thank you. No, I was just going to say thank you, and you have 2 minutes, so we'll come back to you.
Yes, and I would like to touch on my client's sentence in rebuttal, please. Thank you.
Sure. Ms. Gomez, is it? I'm sorry, no. Gorski?
Gorski, yes. Julia Gorski for the people. So in terms of the mixed verdict, as your honors have said, we don't know what was going on with the jury here. But the crucial thing is that besides defendant's possible explanation of the verdict, we have also presented another possible explanation of the verdict. We're not shifting our theory of the case. We're just saying, you know, it's also possible that the jury found that the element of forcible compulsion, which is needed for sex abuse and not forcible touching, was not presented by the evidence. And that explains the mixed verdict.
When you keep talking about also possible, isn't that what Mr. Becker is speaking about? Like the sufficiency of the evidence here, or the weight of the evidence, rather? There's an issue here with the weight of the evidence?
Our only argument on the elements possibility of it is just to combat his argument that the only explanation of the mixed verdict was that the jury completely disregarded and found Vargas to be an incredible witness. It's our position that the weight of the evidence did support the forcible touching charge. You know, the jury's deliberation time and notes indicate that I was taking its duty very seriously. And as defense counsel conveniently leaves out, Court Exhibit 1 was the jury asking for the difference in layman's terms between sex abuse and forcible touching. So again, that just kind of shows they were struggling about these legal concepts, maybe not necessarily the credibility of Vargas or not. If they believed that Vargas was a liar entirely, it wouldn't make sense to, you know, convict on one instead of not the other. And it makes sense, the verdict here makes sense because on the one hand, our witness was clear and consistent on the important points, you know, those being, where did the forcible touching occur? Was it in the locker room? Was it in the hallway? When did it occur? And how did defendant end up in the locker room? On the other hand, it seems defendant either lied the day of the incident, the day of trial, or both. And that's shown by comparing what he said at trial to what he said the day of the incident. So comparing these two witnesses here, the verdict makes sense. The jury didn't have to believe every single one of the acts that Vargas described happened to find the defendant guilty of forcible touching. They just had to find beyond a reasonable doubt that defendant had subjected her to unwanted sexual contact. And as the defendant concedes, if you believe her, it made out those elements.
You want to move to the issue of, the excessive sentence?
Sure. So it's our position that defendant's sentence is not excessive in this case. Irrespective of the fact that this was his first conviction, it was a sex offense. He sexually assaulted a coworker at work in the women's locker room, and Vargas's life has never been the same since. You know, as her victim impact statement described, she continued to feel absolutely disgusted and humiliated about herself. She lost her job. She couldn't look to or talk to her fiance. And she still gets nervous when people start walking too close to her on the street. So in light of defendant's appalling conduct and the impact it's had on the victim, defendant deserved a significant punishment here, not a conditional discharge. And for the reasons that Justice Sonberg expressed at sentencing, you know, the purely probationary sentence was the most appropriate one in this case. Again, because he was a first-time offender and he had dependents who relied upon him to work. So a period of incarceration.
Misdemeanor charge. This is a misdemeanor, isn't it?
Correct. But the purely probationary sentence for sex offense misdemeanor is 6 years. Because again, sex offenses are more serious and there's a higher rate of recidivism. So the probationary term had to be 6 years. But if there are no further questions, I will rest on the brief.
I think not. Okay, thank you.
Thank you.
Back to you, Mr. Becker, Rutgen-Becker.
Thank you. Just very briefly on the weight point, this is not just about the jury's deliberations and the acquittal. I think that's certainly a relevant factor to consider, but when you combine the complainant's inconsistencies, the testimony of Mr. Guzman, that the court acknowledged much of which had come in was fully consistent with his testimony at trial, as well as the acquittal and the jury's difficulty deciding the case, and plus the court's uncertainty as to the facts, that is reasonable doubt in spades. However, moving on to Mr. Guzman's sentence, 6 years probation is a particularly onerous sentence for an individual in Mr. Guzman's position who had had zero prior interaction with the criminal justice system, who worked for years, multiple jobs around the clock in order to support his family and his ailing mother. This probation can really get in the way of his ability to work, and 6 years is a very long term. For those reasons and the reasons detailed in our brief.
What's the minimum term here?
So
on probation.
Correct. So the probationary sentence had to be 6 years. The easiest and most fair course I would submit is for this court to reduce to a conditional discharge. However, the court did not consider one alternative path that could have satisfied the court's articulated concerns here and could have been a middle ground, which was interim probation. Under interim probation, Mr. Guzman could have served a year probation, at which time he would have been, of course, supervised, subjected to any conditions of treatment the court imposed, and then after a year, it could have come back before the court in order to assess whether the 6 year probation term was necessary for him to actually complete the required treatment, or whether an additional conditional discharge with which treatment could have been a condition would have satisfied that.
How many years has Mr. Guzman been on probation now?
He has been on for approximately 3.5 years, Your Honor. And so if this court is not inclined to reduce his sentence, at a minimum, we would ask that he be granted a resentencing where this alternative middle course can be charted before the court, as well as it would be a smooth vehicle for consideration of any updates. A new probation report would be issued, and the court could then assess how he's been doing in that 3.5 years time. So if there are no further questions, thank you.
Thank you. Thank you both.
Thank you.
Anthony Zioli versus Offord Jacobowitz.
Good afternoon, Your Honor.
Jacobowitz, I'm sorry, Jacobowitz, sorry.
Good afternoon, Your Honors. Douglas Shearer.
Good afternoon.
For appellants Anthony and Jean Zioli. I apologize, there appears to be a truck shredding a whole office of papers outside my office. If the court can't hear me, please let me know.
Okay.
The trial court's decision, Your Honors, should be reversed because the respondents failed to meet their burden of proof and to establish entitlement to summary judgment on the lack of informed consent claim. Additionally,
counsel, in this instance, I know that there is there's a written signed consent that the plaintiff agreed that he read, and that specifically refers to the ailment, to the issue, which is difficulty swallowing. And in that signed consent, it says, rarely some patients will report some difficulty swallowing permanently. So wasn't the patient fully informed of this condition?
I don't believe so, Your Honor, because first, as this court has said, just the mere signing of a consent form doesn't mean that the patient received the information they're entitled to under the standard of care and under the statute. The form is not signed by anyone confirming that they even explain the information. It doesn't reference the specific surgery. It's just references different types of throat surgery. And most importantly, it downplays the risk associated with injury in this case.
Well, this is not, I think when you're speaking of another case that says, and I think it's a sexual dysfunction case. I think the Santiago and Corsino cases that you referred to in your brief But those are different in the way they clearly downplayed the risks because they talked about the sexual dysfunction will most likely be temporary. Here, there's no expression of anything temporary. It says permanent. And your client is dealing with swallowing, throat swallowing, and that's specifically stated. And it says, you know, the fact that it says rarely, I don't think changes that. It makes it quite clear that this kind of injury can occur and can be permanent.
Yes, Your Honor, but I think that the key point in the failure on the defendant surgeon's ability to communicate consent and to meet the requirements of the standard of care in the statute is he didn't explain to this gentleman there is a risk of permanent swallowing injury, and it may be small, but if you have the CPAP, if you submit to that, it will treat your obstructive sleep apnea.
Weren't there numerous appointments and numerous conversations with this patient? In fact, the patient canceled appointments. They had to tell him this is a requirement of the hospital. You have to come in prior to surgery. And didn't not only this doctor, but a previous doctor spoke, or a doctor afterwards, I can't remember if it was before or after, spoke to this patient about the CPAP. And he just said, well, it's too difficult, it's uncomfortable. I think he tried it once for a few minutes. He just kept saying he didn't want to do it. They kept coming back to him and coming back to him repeatedly with the importance of getting used to the CPAP.
Right.
And then the doctor says, and I know you challenge this, but the doctor says, I spoke with him about the various issues that could occur.
Well, there were, Your Honor, multiple preoperative visits to discuss the operation. And the fact that the patient has told and makes no issue with the fact that he didn't want CPAP does not mean that the surgeon provided the information that he should have. He was required to tell this patient, I know you don't want it, but it is the treatment that I recommend because it will.
He clearly recommended it. There was no question that he recommended it, repeatedly recommended it.
It never said in the chart he recommended CPAP. As a matter of fact, it never even says he rejected CPAP over my recommendation and he wants to proceed with surgery. He talks about he could try desensitization. So while the surgeon is taking the position that this patient never wanted to use CPAP, all of his boilerplate notes say the same thing. He could try desensitization. Well, if he's rejected CPAP as a treatment option, then why would you be considering and continuing to put the same note and he could consider desensitization? And there also is a requirement.
Is it irrelevant? I mean, is it not important that he seemed reticent to continue to discuss surgery after he decided to proceed with the surgery, that he canceled appointments, that he told the staff that he didn't feel additional preoperative visits were necessary or were needed, that I think he admitted to two doctors prior to Dr. Jacobowitz, that two doctors prior to Dr. Jacobowitz had encouraged him to use the CPAP. And that to give it an earnest try, and he rejected that?
I don't believe that's accurate, Your Honor. I think there are references in other physicians' charts that he had tried CPAP and didn't like it. That's not the same thing as the obligation on the surgeon to communicate to him that I'm recommending CPAP and that I want to document that you are rejecting that recommendation and you want to proceed with surgery despite knowledge of the risks and knowledge that CPAP will treat your condition without any risks of surgery. Tony Zioli says, nobody told me that. I didn't want to use a mask. Nobody would like to use a mask. So what he should have been told is, I know you don't want to use it, but you can get hurt badly in this surgery. It may be a rare risk, but if you try the CPAP, none of those risks will be there. The CPAP will treat your problem that you do need treated, and it will treat it without any risk of surgery, and you need to get used to it. Now, if you don't want to do that, then it would have been very easy for the doctor to document that
Counsel,
in the chart.
Judge Scarpula, how do you explain that Winston Qua's notes in his records where he says that plaintiff was advised and then he tried to use the CPAP, he couldn't tolerate it, he since stopped, and he's scheduled for surgery? I don't know how you can get around all the doctors. you seem to be saying in some ways that this plaintiff shouldn't be able to make his own medical decisions. It's clear that he did.
No.
He initialed pages on a document, and not only this doctor who you're suing, but several other doctors also explained to him what was going on, the use of CPAP, and he nevertheless scheduled the surgery. So it seems to me that you're saying that the doctor should have overridden him. And
No.
I don't know how he could have done that.
I am not saying that, Your Honor. What I'm saying is that the fact that it's documented in other charts that he had tried CPAP to address.
And that he was scheduling surgery after.
Right.
Not just tried CPAP, that he rejected it and was scheduling surgery.
But Your Honor.
That's what the note says, right?
Yes. But those doctors don't have the obligation to obtain an informed consent and to make sure the patient can make a knowledgeable evaluation. They're just writing down in the chart he's going to have surgery. The issue is, why is he having surgery? Did he know the risks he was subjecting himself to, and that he could avoid those risks if he tried CPAP?
Document that said he did, right? He actually he signed a document that said he did. He initialed every page of it. He signed it. He testified that he understood what the CPAP was and that he couldn't tolerate it. I don't know where this issue is. Where are you saying, what is it that you're saying? He testified that he understood the CPAP, and he signed a document that has never been challenged, saying, I understand this. So
and he said, and he agreed that he read it.
Right. So, Your Honor, the point is, though, he did not have the statute requires the surgeon to communicate to the patient, and it's subjective.
Why would he sign a document that said he understood it if he didn't?
Because
he signed a document. It's not that it's not there's a medical record, an admissible medical record in which he acknowledged that he was told the risks and he understood it. So why isn't he bound by that?
Because the defendant is obligated to establish that they explained to him before.
Well, they put in that document. That document is a record, a business record, a 4518 business record, where he says it and signs it.
But before,
so that's there it is.
But before, Your Honor, he can give an informed consent and sign that form, the defendant has to show that he gave enough information to the man to make a knowledgeable decision. So just telling him, look, if you don't like CPAP, we can do surgery, is not the same thing as explaining to him, you can have permanent injury from the surgery, or you could do the CPAP and you won't have those injuries.
But isn't that what he was told, counsel?
That was not what he was told, Your Honor. That's the error I believe the trial court made, is the judge just read into these entries that the defendant surgeon explained certain things that could have easily been put into the chart. It would have been very easy to say, I have recommended that he try the CPAP. It will not have the risk of injury of the surgery. He is rejecting that option and would like to proceed with surgery. He could have easily put that in. He's put it in all the briefs and the motion papers, and he didn't once put it in the record.
So the record says that Dr. Mehta advised CPAP. Your client tried it. He rejected it because he said it was too uncomfortable. He felt claustrophobic. Then he was offered oral instrumentation. He rejected that also. He said he wanted surgery. He comes to Dr. Jacobowitz, who on more than one occasion says, I'm in the record, he's in the record, and he testifies to that under oath at his deposition. I explained to him, CPAP is something you should use. He rejected it. He said he wanted surgery. I scheduled him for surgery. Then he signs the release. I mean, that's what the record says. We have the informed consent that was signed by your client. We have the doctor's deposition testimony. So what else do we have to go on?
Well,
what else do you want from Dr. Jacobowitz? Well,
the point is, I feel that the lower court had accepted that the doctor's testimony explaining a note entry saying what I really did is I said all the things I'm supposed to say. That's what that entry means. And when the patient says he didn't say that to me, that's rejected as self-serving and speculative. But the doctor is allowed to say, when I said repeatedly he can try desensitization, that was in response to him having rejected CPAP from day one.
No, but counsel, it's not just that. It's a document that says this can happen, which your client read. he acknowledged, he read, he signed, he understood. It's not just the doctor saying it in the doctor's medical records, which are, of course, medical records and admissible. It's also in a document. The informed consent says specifically what you're saying the doctor should have told him, and
Right.
your client signed it and said, "I understand it."
But-
So what more is there?
Because what I think a jury is entitled to know is what information was the patient presented with. All these informed consent forms and forms that patients sign, most of them are told sign here, sign there. They have no choice. And the doctor tells them, don't worry about this. I've done this surgery. We're going to fix your problem. If you don't,
Thank you. Let's hear from Ms. Goldberg and we'll come back to you. Okay,
All right.
Ms. Goldberg.
Thank you very much, Your Honor. Barbara Goldberg for the respondents, Dr. Jacobowitz and ENT Allergy Associates. It's my position, our position.
Ms. Goldberg, where does it show that the doctor wrote on any document that he discussed, in the medical records I'm talking about, that he discussed the issue of permanent swallowing and the patient rejected it, or that he discussed the CPAP and the patient rejected it?
Your Honor, there are numerous references in the medical records to the patient's inability to tolerate the CPAP therapy. There is also a specific reference where it says that the risks of swallowing difficulties were included at page 149 of the record. It's part of the records of ENT Allergy Associates. Risks discussed included pain, bleeding, trouble swallowing, narrowing, scarring, partial result or failure, aspiration, nasal reflux, and other risks. So there's a specific contemporaneous documentation that the risk of trouble swallowing was discussed. And I think that when that is taken together with the form at page 271 of the record, which has been discussed already, the patient specifically acknowledged and initialed statements on that form that said that the risk of swallowing difficulty can be permanent. Quote, rarely, some patients will report some difficulty swallowing permanently. So this, taken together with the numerous entries in Dr. Jacobowitz's chart, documenting not just the patient doesn't want, quote unquote, to use CPAP, but the patient has repeatedly tried CPAP and cannot tolerate it. And as was mentioned previously, it's not just Dr. Jacobowitz. It's also the records of Dr. Winston Hua, who was treating him basically simultaneously. At page 1588 of the record, Dr. Hua documented that the plaintiff reports that he can't take CPAP despite his OSA being severe. He has tried it and cannot use it. Plaintiff himself said at one point, he testified at his deposition, this is at page 1049 of the record, that CPAP, quote, was not going to be my answer to peace. The patient knew about CPAP. He had tried it repeatedly. In fact, he had tried it with Dr. Hua in November of 2014. He was again unsuccessful as late as February 13th of 2015. This is slightly more than a month before the surgery at issue. Dr. Hua noted that he, quote, tried to use CPAP the past few weeks and could not tolerate it. He has since stopped. That's at page 1591 of the record. The plaintiff also referred to CPAP or any kind of appliance on his face giving him flashbacks. He had worked at Ground Zero and he testified that having the device on his face actually gave him flashbacks. And that's at page 1049 of the record. So I don't think that there's any question that he was certainly aware of CPAP as an alternative to surgery. By his own admission, he couldn't use it. He had tried it numerous times and couldn't use it. And there's also testimony from Dr. Jacobowitz that at one point he said to the patient that he could bring the machine into the office and Dr. Jacobowitz would look at the settings and see if he could do anything with the settings to make it more comfortable for the patient to use. That didn't happen. The patient didn't come in. Dr. Jacobowitz also testified that he suggested desensitization to the patient, that he put the mask on without attaching it to the machine for a couple of hours before bedtime and perhaps get used to it that way. So I think this record amply documents that Dr. Jacobowitz did make attempts to get him to use CPAP, that he did make previous attempts to use CPAP, but because of his own particular sensibilities, he was not able to use it. And the other side of the coin that we really haven't discussed so far is the severity of his obstructive sleep apnea. This man at times had oxygen desaturation as low as 86%, which, as we explained in our brief, is a very, very serious condition. His OSA put him at increased risk for a number of conditions, cardiovascular conditions, stroke, even risk of accidents when he's out driving. I think there's a reference to a risk of death as a result of the OSA. So this is another factor that weighs in favor of him understanding exactly what his options were, making an informed consent, an informed decision to proceed with the surgery. And as was noted, at one point, very, very shortly before the surgery, he was asked to come in for a preoperative appointment, and he said that he didn't want to do so because he had made up his mind for the surgery, and that was it basically. And the last point that I would like to make is that the plaintiff's position, if we carry it to its logical extreme, that almost means that a doctor has to affirmatively attempt to talk a patient out of a procedure before informed consent can be obtained. And that's not what the law is, and that's not what the statute is. And again, I think it's more than amply documented in the contemporaneous records and the consent that the patient signed, that he did know his alternatives, he did know the risk of injury, and he made an informed decision. And it's very, very different from the Corsino and the Santiago cases that the court mentioned.
Thank you.
Any further questions, I'll rest on the brief.
We're back to you, Mr. Shearer.
Yes, Your Honors. So I think the defendant's position taken to its extreme is essentially if the doctor writes a detailed enough note and doesn't say a word to the patient will lose on summary judgment on informed consent. There will never be an opportunity for a patient to say what is in that chart did not happen. And here, they didn't even write that type of note. It would have been very easy. The fact that he concedes he knows CPAP is a treatment option. The fact that he knows that doesn't mean he was given enough knowledge or information to make a knowledgeable evaluation to reject CPAP and proceed with surgery where he could have the injuries that he has here. The fact that he spoke about this, that I know about CPAP and I don't like it, to other physicians does not relieve this surgeon of his obligation to get informed consent from the patient, which he did not do. He could have easily written the type note that his lawyer is urging in this case, and he didn't do it. So as to the consent form, the risks were certainly downplayed because the respondent's expert says in her affirmation in support of the motion, the risks of a permanent swallowing injury are well known. They're about 20%. Now, they wouldn't be well known to Mr. Zioli. They're certainly downplayed in that consent form where they say risks of permanent swallowing injuries are rare. So the surgeon, the expert for the defendant is saying, hey, this is a well-known risk. Don't say you weren't told about it. When the consent form, which doesn't even specify the surgery, tells the patient, check off which surgery you're having, makes it very clear that permanent swallowing, the very risk that their expert says is a well-known common risk, is very rare in this case. There is absolutely nothing in the chart that documents that this patient is rejecting my recommendation of CPAP as a treatment option. The fact that he has severe sleep apnea, both the expert and the defendant surgeon agree CPAP would have treated this man without any risks associated with surgery. And the court,
thank you.
And if I may, on just one other point, Your Honor, the court also accepted on the issue of causation, the respondent's expert literally said he may have had GERD too that contributed to this. And the court said, well, that has now shifted the burden to you. There is no opinion that GERD was the cause of this guy's injuries to a reasonable degree of medical certainty. It's another question of fact They opened another question of fact up here. They're just asking, the court just rejected his testimony and said, I believe the doctor because his chart mentions CPAP and says you don't like it. That means you had enough information to proceed here. And we're not even going to listen to what you have to say about it.
Okay. Well, we're going to consider the entire record. So
okay.
Thank you very much. Thank you both. People versus Daisy Rangel.
Good afternoon, and may it please the court. This is Amelia King-Musa for Appellant Daisy Rangel. The primary goal of the DVSJA is to shift how New York courts think about domestic violence, and in particular what it means to be a victim of domestic violence. As a remedial statute, the DVSJA should be read and applied broadly to effectuate this goal. Ms. Rangel's case is precisely the type of case that the DVSJA set out to reach. The instant encounter was a clear result of Ms. Rangel's decades-long, uncontested history of severe domestic
abuse. I know that you say that this is exactly, that it should be read broadly, and that this case is exactly the kind that the legislature set out, or the DVSJA is set out to reach. But what about the fact that the legislature amended the statute in 2019 and seemed to narrow its application?
Respectfully, Your Honor, the 2019 amendments broadened the statute in multiple ways. The requirement that the abuser be the victim of the crime was removed. There were multiple, the number of crimes and the types of crimes which were put under the statute was also enlarged. And the causal nexus standard was also different as well. These are all indicators that the DVSJ is a remedial statute intended to broaden relief here. And the trial court's order below reflects really an outdated understanding of domestic violence that the DVSJA was specifically aimed at changing. We now understand the scientific effects of long-lasting.
What about, for example, that it says that the person has to be a victim of substantial abuse at the time, I believe it is. I think that was
at the time of the offense.
At the time of the offense, that was language that was added, I believe.
Yes, it was, Your Honor. And
doesn't that narrow it? I know you mentioned it broadens it in some issues, it does, but doesn't that narrow it?
Not once the scientific understanding, the accepted scientific understanding of what it means to be a victim of domestic violence is understood. It's well accepted in the scientific community that the effects of domestic violence don't end the moment the victim is able to escape her perpetrator. Studies have shown that the trauma inflicted by domestic violence is so ingrained that many survivors exhibit exactly the same cognitive mental functioning once they leave an abusive relationship as they exhibit when they are still in an abusive relationship. Even a report from the Manhattan District Attorney's Office cited in the brief demonstrates this. And with that understanding, Ms. Rangel was a victim, quote unquote, of domestic abuse at the time.
What admissible evidence did you put in the record, or I'm sorry, did defendant put in the record to show that the domestic abuse was a significant contributing factor to what she did? So, I mean, she went and slashed a stranger's face. It wasn't her abuser or anyone in her family. It wasn't a fight. It was an unprovoked attack. So my question to you is, what evidence did the defendant submit in the record that would connect her crime with her abuse?
Certainly, Your Honor. There are multiple psychiatric evaluations in the record which connect Ms. Rangel's mental health issues and substance abuse issues directly to her abuse. And
I don't think that's right. They connect it to her recidivism, but not to this crime. Where in the record are you saying that someone connected her abuse to this crime?
So what is explicit in the record in 2 of the 730 reports is that Ms. Rangel's mental health issues and her substance abuse issues stemmed from her abuse.
Her abuse, the abuse. She has mental health issues, But I mean, I'm asking you again, what specific evidence is in the record that connects her domestic abuse to this particular crime?
Sure. So when we look at her mental health issues,
I just want to know what is specifically can you quote something for me? Like in the record, some expert or some psychologist or some social worker or someone who did her pre-sentence report actually said this crime is connected to her, or anything that would like directly say that.
Right.
So did you submit any psychiatric reports that actually say that?
In the 730 reports, they connect her paranoia and her confrontation directly to a reaction from the trauma of her abuse. And in this particular instance, what she is doing is reacting and becoming confrontational with someone, which is the exact, textbook definition of her reaction from abuse.
Does anyone actually say that? I know you say that. That's your argument, but you're a lawyer and not a psychiatrist and not someone who has the ability to put in that kind of evidence, right?
Yes. So I believe the Gordon report and the Rosner report both cite to that.
Yeah, but I read them both, and neither one of them connects this specifically. They're talking about her recidivism, her general mental health, right?
Right, and they
There's something I missed. That's what I'm asking. I'm not trying to. I'm trying to see what exactly is it that they're saying that you think connects them.
Absolutely. What connects it is they are drawing the straight line from her abuse to the paranoia and the mental health issues which precipitated this event. And I think my argument makes much more sense when we understand that the causal nexus in the DVSJA now is that the history of abuse has to be a significant contributing factor and not the causal factor, which is what the standard was previously before the statute was amended. And with that in mind, once you understand that without her history of abuse, she would not have these substance abuse or mental health issues, it becomes clear that her history of abuse was a significant contributing factor to the commission of this offense.
Was there anything in the record that said that at the time she committed the offense that she was hallucinating or having any issues with respect to her mental health?
Yes, in the Rosner report at page 2, it says that she often had flashbacks where she felt again like she was being assaulted.
No, I know, but I'm talking about this offense, not in general. That is, I guess, my issue. There's no doubt in general there is information, but I'm trying to say, is there a connection to this? Because the statute requires the connection to the crime.
Right. The statute requires at the time of the offense, and all of these mental evaluations occurred at the trial level right around the time of the offense. They don't go specifically to the minute and the hour that it happened because she herself was in such a mental state that often she could not recall an hour or a time or a day. And that is actually precisely what some of the evaluations say, that her mental state was so affected by all of her trauma that she would lose track of days. She was addicted to substances such that at this time period, they say, right around the time of the offense, these months and days, this is how she was acting.
Okay. Counsel, ultimately, what you're seeking is to have this defendant resentenced within the VSJA statute. Is that what you're seeking?
Yes, Your Honor.
Okay, and the maximum that someone could get under that statute would be 8 years in jail and 5 years post-release supervision.
Yes, Your Honor, for her specific offense. Yes, Your Honor. And our request is modest, as Ms. Rengel has already served the incarceratory portion of her sentence. So a reduction here would allow her to leave post-release supervision early. She has a strong support network, particularly with her sister in New Jersey, which she has been prevented from fully relying on because of the post-release supervision here. And I just wanted to direct the court's attention to the trial court order because I think it hits on some of the misunderstandings that the DVSJA was trying to correct. The trial court order found that Ms. Rengel's myriad mental health that the quote primary factors of the instant offense were Ms. Rangel's mental illness and substance abuse issues, end quote. Again, for this DVSJA to apply, it does not have to be the primary factor, but it has to be a significant contributing factor. And once we understand that the root cause of both of these, the center of everything, was her history of abuse, it becomes clear that, you know, her history of abuse cannot be compartmentalized or separated from her mental illness and her substance abuse issues. They are intertwined. And for that reason, you know, it was a significant contributing factor. The question is, was the trauma ongoing? Was the abuse still affecting her thought processes and behaviors? Was the continuing trauma she experienced a contributing factor? And here it very clearly was.
Thank you.
Thank you.
Ms. Figueredo?
May it please the court, Valerie Figueredo for the people. Defendant's argument for resentencing fails for 3 independent reasons. Going to the first one, she simply has not shown that at the time of the offense, she was a victim of domestic violence.
So what does that mean? What does it mean in the statute at the time of the instant offense? Does it mean that you have to be a defendant as the defendant was in the Smith case? Or is it okay to be a defendant as the defendant in the Lagos case, or Lagos, whichever it is?
Right.
Because it seems like this case falls somewhere in between.
Sure. The natural interpretation of the statutory language requires that the defendant be in an ongoing abusive relationship, that there had been either some abuse within a reasonable time prior to the offense, such that she would still be under the effects of that abuse. That was certainly the case in Smith.
This is 10 months. This is 10 months. Is 10 months such a long period of time that she wouldn't still be under the effects of the abuse?
It's not just 10 months since the last instance of the abuse. She wasn't even in the abusive relationship anymore. In Smith, there was no indication that the abuse had ended, and there was every indication that that ongoing relationship with the defendant, that the relationship with the defendant was still ongoing. The legislature did not write the statute in using a verb in the past tense. They could have, previously the statute just said that the defendant had to be a victim of physical, sexual, or psychological abuse. If they had wanted the abuse to be in the past, they could have left it the way it was. There was no reason to add the at the time of the instant offense. Addressing your question with regards to law. So is your
position that the statute narrowed the circumstances under which someone could fall into this?
It is our position that it did. What the legislature did was that it eliminated the requirement that the victim had to be the defendant's abuser. But that necessarily broadened the scope of the statute, but they still wanted to ensure that the criminal behavior and the abuse were directly related. To do that, they added the at the time of the instant offense language, which requires a temporal nexus between the abuse and the criminal offense. And that, again, is clear from the plain text, because if they wanted to account for past abuse, all they had to say was that they could have said that the legislator had been, the defendant was abused in the past, or they could have just left the statute the way it was, which was just to say that the defendant was the victim of physical, sexual, or psychological abuse. What they instead did was add very clear language that requires a temporal nexus. Just addressing the Lagos case, it would be our position that childhood abuse that happened long in the past would not suffice to meet the statute, but the court doesn't have to reach that conclusion here, because even if you believe that past abuse was sufficient, the defendant here simply did not show a nexus between that past abuse and the instant offense. She did not show that she was suffering the effects of the abuse at the time that she assaulted and slashed a stranger.
I don't understand that. The Lagos case, it was 30 to 40 years, I think. So
yes,
why in this case, when the abuse was 11 months ago or 10 months ago or 12 months ago or whatever the amount is you want to suggest that it is, she was abused, and then she, from there, I think, became an addict the same way, and then she was doing things to ensure she got her drugs, stealing, etc. And
so
in this
instance, in Lagos, there was evidence that the defendant in Lagos was acting under the effects of the abuse. There was written documentation from treating psychologists who opined that the defendant at the time of the burglary in that case was acting under the effects of the abuse. We do not have that evidence here. Two, it's not clear from the law.
So you're saying that a psychologist has to specifically indicate that the one is related to the other?
You don't necessarily need a psychologist to, like an expert witness, to opine on that. It would certainly be sufficient to establish it, and that's what they had. They had evidence, either psychiatric evaluation reports in Logos that showed a direct connection that the defendant was still suffering from the effects of the childhood abuse. Again, we do not have that evidence here. In fact, what we do have is a statement in a CPL 730 report where Ms. Rangel admitted that she believed that it was her substance abuse, which predated the domestic violence, because the substance abuse began when she was a teenager, and she believed it was a substance abuse that had caused her to enter into these bad relationships, which then caused her to be abused. So here, as Supreme Court found, there just simply wasn't a link showing that the substance abuse and the untreated mental health issues were directly caused by her domestic violence. Going to the second factor, the legislature added the significant contributing factor in the statute. Prior to that, it only required the domestic abuse to have been a factor. Defendant's argument would simply read out of the statute the entire significant contributing language that was added with the amendment. The third independent reason why defendant's claim for resentencing fails is she simply has not shown that, given the nature and circumstances of the offense here, that her sentence was unduly harsh. Defendant has 29 prior misdemeanor convictions, 1 prior felony conviction, and she received the minimum allowable sentence that she could receive given that she was a predicate felon. If there are no further questions, we ask that you affirm for the reasons stated in our brief. Thank you.
Thank you. We're back to you, Ms. King Musa.
Sure. I'd first like to address counsel's point that defendant, quote, did not show that she was suffering the effects of the abuse at this time. What are the effects of domestic abuse if not for depression, anxiety, chronic paranoia, a deep and anxious mental state, bipolar disorder, PTSD? To put it in a very rough analogy, one can be a victim of a physical wound without having that physical wound still impact them. Again, this is a rough analogy, but one can be a burn victim even when you're not still on fire. You feel the effects of this and you're still a victim of something, even if the act itself is not happening to you at that precise, second in time. What we have in the record are multiple psychiatric evaluations from different people showing that Ms. Rankel's state was deeply upset and connecting that to her abuse. And just to quickly comment on the unduly harsh aspect, Ms. Rangel was given the minimum before we understood, and we had this mandate from the legislature to think differently about victims of domestic violence. Now that we have this and there's a ameliorative statute, a minimum, again, would be appropriate. If there are no further questions, thank you.
Thank you both. Very good arguments. Thank you. Gray versus the City of New York.
Yes, Nolan Matz, Your Honor, may it please the court, for the plaintiff appellant. This is a case where Thelma Gray was caused to trip over a raised manhole cover.
I'm sorry, Mr. Matz, just let me see. Is Ms. Steiner with us? I know there was some issue with her connection or not being here in the beginning.
She did not answer in the initial call.
Exactly. I'm just trying to see if she's here now. Ms. Steiner? No, I don't see any indication that she's on with us. So I'm going to give you 3 minutes.
Thank you, Your Honor. In this case, it's irrefuted that Ms. Gray was caused to trip over a raised manhole cover. Deposition, I deposed Mr. Thomas Verdone, who is a supervisor at DEP, and his job is to install sewer casings and manhole covers. In this particular case, or in every case involving manhole covers and sewer casings.
So Mr. Verdone indicated, I think, that he couldn't say that this happened when it was first installed, and he has no record in the last 2 years that there was any repair work. There's the discoloration of the sidewalk, but he said that's not an indication because it could have just been the choice of whoever was doing the work initially. So what evidence is there that you have that this was, that the city created this?
What we have, Your Honor, is DEP is the entity that installs sewer casings and sewer manhole covers. The only way this could possibly happen, to have a raised manhole cover, you have to understand that the DWS, Department of Water Services manhole cover, is 150 to 200 pounds. It's seated in a metal manhole casing, which is 6 to 12 inches of solid steel.
What manholes look like. I understand what you're talking about, but the question is proof, not speculation. For all I know, there could have been some 10-ton truck that ran over it, with chains on the tires, and it went up. I have no idea. I'm just asking you what proof you have that the city caused this.
The proof is one. I'm sorry. The proof is one that it's on the sidewalk, so no vehicle's going to run over it. But second,
I don't know about that, but in any case.
Okay, if you look at the pictures on page 429.
I don't doubt it's on the sidewalk. I'm just saying that doesn't include something from going over it.
Right, but what I'm saying is that the manhole cover is seated inside the manhole casing. Once that's put in, it's metal on metal. It is not going to move. And with regard to any subsequent or possible prior repairs of sidewalks, the sidewalk does not abut the manhole cover. It abuts the manhole casing. So the sidewalk, whether it's put in properly or not, is not going to affect the seating of the manhole cover. Again, that's on 6 to 12 inches of solid steel. Mr. Verdone clearly said when I asked him, question is, what I'm asking is, could a manhole cover, a DWS manhole cover, be raised by itself in any manner other than the way it was installed? His answer was no, period. And then he says, I don't think so.
But Mr. Verdone also indicated that he couldn't tell from the fire hydrant photo whether the raised condition of the manhole cover resulted from the way it was installed. And that's at page 466 of the record.
That is correct. The way it was installed. You're absolutely correct, Your Honor. The way it was installed is the only way that a manhole cover could be raised. Mr. Verdone.
What evidence did you present? Because this is what you're saying, but I don't see anything in the underlying motion proving what you said.
The only evidence we have is Mr. Verdone's testimony that this could not happen in any other way other than the way it was installed. Again, it's impossible to happen any other way. There is no expert testimony.
Counsel, you're a lawyer, right? You're not have you ever done a manhole cover? Do you know anything about manhole covers? So you're saying to us, this is the only way it could be done, is like me saying I have to do brain surgery this way. I know I'm not a brain surgeon. You know you're not someone who does that kind of work. So your argument is what it is, and what Judge Kennedy asked you and what I kind of want to know too is, what evidence did you put in about that? And if you're talking about the testimony of Verdone, what else? Because I don't even think we agree that he said what you think he said. So what else do you have? If that's it, then that's it.
That's it, Your Honor.
Okay, so let's move on to the special use, because then how does the manhole cover serve a proprietary purpose rather than a governmental function that benefits the public?
Well, the proprietary services, what it does is the manhole cover, it's different from a sewer manhole cover, which opens into the sewer, versus a Department of Water Services manhole cover, which opens up into the actual mechanics of turning the water on and water off. So it is believed we is similar to the Posner case, where the Transit Authority had a special use of a manhole that went down to equipment that they used to run the system. It's similar to here, where DEP would only exit or use the Department of Water Services manhole to get access to equipment that turns on and off the main water system.
Yeah,
Thank you very much.
Shut the mains if there's a water main break to avoid flooding. How does that compare to Posner? I don't see it.
Well, again, it's just access to underground equipment that turns the water on and off.
Thank you. I've given you more than your 3 months. 3 months. Good thing it's not 3 months. 3 minutes. Thank you very much, Mr. Matt.
Thank you.
Okay. Vasquez versus RXR Realty LLC. Mr. DeStefano, I see that you are on board.
Yes, Your Honor. Good afternoon.
Yes.
May it please the court, Anthony DeStefano for third-party defendant appellant Global. I understand that the renewal appeal is non-enumerated, so unless the court has any questions about that appeal, I will just be focusing on the dismissal appeal.
That's right.
Regarding the dismissal appeal, the entire claim against my client should have been dismissed based on anti-subrogation grounds. It was very clear from the third-party complaint what the third-party plaintiffs were attempting to do in this case. They specifically said that they were declining to pursue my client for contractual indemnification because that would trigger my client's coverage under a contractor's controlled insurance program, general liability tower of insurance. So for that reason, against the backdrop of North Star, which is the Seminole Court of Appeals decision on the anti-subrogation issue, that we are to prevent insurers from manipulating litigation in that manner, the entire claim should have been dismissed on the basis of anti-subrogation. If not on the basis of North Star, then it's very clear from the entire purpose of what a CSIP is intended to do. It's intended to prevent one party to the project from suing another party to the project, because the whole point is to cover everyone under the tower of CSIP insurance so that we avoid that type of situation. And we lay out in our brief.
Don't we have to look to the terms and to see what the terms of that insurance policy actually say? And here in the policy, I think it, I'm trying to find it, I'm sorry. It speaks to any liability. Let me see if I can find it.
Page 872, Your Honor, if that helps.
Yeah, any liability. Yeah, the policy said any liability arising from an employee's bodily injury. And then it goes on to say, I'm sorry, I'm reading from two different things here. It goes on to speak about, I'm sorry.
It's where the obligation of any underlying insurer providing employer's liability coverage for the insured is by law unlimited.
Exactly. Thank you. So isn't that saying that if there's something else that exists, I mean, doesn't it exclude any liability? I mean, isn't that what any is for? Isn't that what it's doing in that section?
Well, no, Your Honor, and we know from the Hedges case that this court recently decided just a few months ago with regard to a contractual indemnity provision. This court took the phrase any and all liability and limited it. It narrowed it down to the following phrase, which was arising out of the performance of services by the proposed indemnitor in that case. So here what the argument is that the specific language is not just any liability, it's the following phrase after that, where the obligation is of the underlying insurer providing employer's liability coverage. Now, employer's liability coverage is a term of art. It means coverage for common law indemnification, because employer's liability coverage does not provide coverage for contractual indemnification. Part 2 to a workers' compensation employer's liability policy is limited to common law indemnity. It's not contractual indemnity. And here it becomes even more concerning because, as we know, the law is well established that if an insurer wants to exclude coverage, it must do so in clear and unmistakable terms. There are 2 points in this policy prior to endorsement number 13 where contractual indemnity coverage is referenced. The first is in the coverage grant itself, the very coverage agreement, where it says that insured contract, which is contractual indemnity, is covered. Then there's an exclusion for contractual liability. But even then, the insurer adds back coverage for contractual indemnification. So we know that this policy covers contractual indemnification using the language insured contract. However, when we get to endorsement number 13, there is no longer any reference to that. The reference to insured contract or contractual indemnification is gone, even though it had been used twice before in the policy. So if this insurer wanted to exclude contractual indemnity, then it should have done so in clear and unmistakable terms. And,
so you're saying we should have a narrow reading of this where we sort of take out the word any?
No, Your Honor, you don't take the word any out. You just use the word any in conjunction with the remainder of the phrase. We don't isolate the term any, and that's what this court in Hedges did the same thing. The law was clear prior to Hedges that from Levine versus Shell Oil, that the word any and all meant including claims for the negligence of the owner. But this court looked at the indemnity provision in Hedges and said, not so fast. Any and all does not mean indemnity for the negligence of the owner. It means whatever the following phrase is. And the following phrase after the word any and all was arising from the performance of the services by the proposed indemnitor. And the court narrowly limited that. And that's what we're arguing here, is that the court should narrowly limit it based on the following language. And the Court of Appeals has made clear that from the North River versus United National case, 81 New York 2nd, 812, that, in that particular case, they talked about a injury arising out of the bodily injury to an employee, but then it went on to say that it also included any obligation of the insured to indemnify another because of damages arising out of such injury. So that case, they clearly did add the words indemnify to signify that they were excluding all indemnification coverage there. And even if we wanted to give the endorsement number 13 such a broad interpretation, even though that's contrary to the law, we would look to whether or not the insurer has ever asserted that exclusion as a disclaimer of coverage. And there we have two problems, right? We have the problem that the court looked at this, the trial court looked at this and said that, well, you did not give proper notice under the policy to begin with to trigger the insurer's obligation to disclaim coverage. But that was wrong for a couple of reasons. Number one is, first, we have Hunter Roberts admitting in their motion papers that the insurer had notice in January of 2020 when it received the motion to dismiss the third-party complaint. The disclaimer comes, according to Hunter Roberts, when they file their opposition 163 days later. That is clearly untimely as a matter of law. There's no justification for the insurer to delay 163 days in disclaiming coverage. But more importantly, we look to why the court was wrong in the first instance regarding notice. A letter was written to the insurer in March of 2018, at which time it was explained that Global was insured under the CSIP tower. The carrier specifically noted that as to the particular excess policies that followed it, Global was insured under those policies. The carrier also noted that there was an injury to a Global employee. The carrier also noted that not only was it an injury to a Global employee, but the injury was paraplegia, which constitutes a grave injury. So at that time, that carrier had all of the information that it needed under the case law that has interpreted that provision to understand that there was a potential claim against its insured, potential for a claim, I should say, against its insured, to begin its investigation. And if it was going to disclaim coverage, then it needed to do so reasonably thereafter. And now we have a period of over 2 years. There's still no disclaimer of coverage. That letter was written in 2018. We're now in 2021, and there's never been a disclaimer of coverage from that carrier. So for that reason, even if you could give effect to that endorsement and exclude contractual indemnification coverage, then it would be incumbent on the insurer to disclaim coverage, which it has never done and is therefore now stopped from ever doing so. So for that reason, we don't even get to the exclusion. The final point I just wanted to make very quickly, because I understand that my colleague will reference it, is that they're excess, right? The argument is that, well, they're an excess insurer, and therefore the priority of coverage is that they don't come into play until all underlying insurance is exhausted. And here, the underlying insurance is unlimited, so therefore it can never be exhausted, and therefore they can't have anti-subrogation. I would stress that under the Jefferson decision from the Court of Appeals, very clearly says that even as to an excess carrier, there can be anti-subrogation, and for that reason, the claim would be barred, even though they're trying to rely on being an excess carrier.
Thank you. Mr. Simone?
Good afternoon, Your Honor. Christopher Simone for the respondents. I'd like to pick up on the last point that Mr. DiStefano raised, because that's really the simplicity of this case. This case, the issues of exclusions and disclaimers and notice are completely irrelevant. The court was correct to deny their motion to dismiss, but there's a simpler reason for it. And it's an analysis that the court didn't address in its decisions. And it's governed by this court's own case, Liberty case, which was cited by the Second Department in Tully, and which also is supported by the Second Department's Arthur Vincent case. And interestingly, it's the case that Global has asked this court to reconsider. And the reason that the anti-subrogation rule does not apply here is because, as per the insuring agreements, the lead and high excess policies were never triggered with respect to Global because the plaintiff suffered a grave injury. These policies, the National Union and the Lexington policy, are not escaping liability. They still apply to Hunter Roberts, but they don't apply to Global because the retained limit of these policies, and Justice Renwick, you kind of alluded to this, in that you have to look at what the policies say. The National Union and Lexington excess policies were excess to the retained limit. The retained limit of the CSIP included Arch's EL policy. Once the plaintiff sustained a grave injury, that EL policy was triggered, and it will never be exhausted. And because it will never be exhausted, Global does not have the benefit of the excess policies. It purchased its own policy. And I think it's important to point out that while they talk about CSIPs are not, you still can have litigation in CSIPs, as this court well knows. And this policy, this CSIP, does not have a waiver of subrogation clause in it. If it didn't, we wouldn't be here right now, because that would mean nobody can sue anybody. But it's not a one-size-fits-all analysis. You have to look at what's in the insuring agreements. The Lexington and National Union excess policies are simply not triggered. And under the Liberty case and Tully case and Arthur Vincent, if it's not triggered, there's no duty to disclaim because there was never coverage in the first place. The Court of Appeals has said that in Zapone. If there's no coverage, you don't have to disclaim anything. So those other issues, while we agree that the court, we argue that the court is correct in denying the summary judgment motion, it's a much simpler reason. You don't have to get to all those other issues because the anti-subrogation rule was never triggered here because those excess policies were never triggered as to Global. It's as simple as that. They'll never be exhausted, and you have to go by the retained limits. And that's exactly what happened in the Liberty case. You looked at how the policies were stacked, and if the retained limit is not going to be exhausted, which in this case it never will be, then you don't get to the excess policies for this. That's the way these policies were written. Arch provided that EL coverage, not National Union or Lexington. So you have to go by what the insuring agreements, not some general notion that if you're enrolled in a CSIP, you can't be sued. That's not true. If they wanted that, they would have put in a waiver of subrogation clause, but they didn't do that here. So we agree the court was correct in its interpretation of the exclusion notice and disclaimer. None of those are relevant here. We didn't have to disclaim because the policy was never triggered, and everybody knows that if a policy is not triggered, there's no duty to disclaim. And on the notice issue, I want to point out one thing. That letter from Dodge was not, Arch is a sophisticated carrier. If it wanted to give notice of an occurrence, it knows how to do that. That letter was not on behalf of Global. It was from Arch, and it was just to line up coverages for the defendants. Global was not a defendant at that time, and it never will be because plaintiff hasn't sued. The letter merely sought to confirm that AIG acknowledges and appreciates the possibility that the judgment would exceed the Arch CGL policy. I don't think that's in dispute here. And it listed the parties obligated to defend and indemnify. Global was not a party. And the interesting thing, that letter completely omits any mention of the Arch EL coverage for Global. It mentions Global, but doesn't mention that policy that provided unlimited coverage to Global, because this is in New York. But it did mention plaintiff's paralysis. If by mentioning the paralysis, it has to have conceded that policy was triggered. If that policy was triggered, there was no excess for Global, which was not a party to any action at that time. So the notice issue is a red herring. It's irrelevant. The exclusion issue, if anything, the exclusion confirms why the policy wasn't triggered, because their access to the retained limit that includes that policy. If this were in New Jersey, then you wouldn't have unlimited coverage and you need other policy provisions. But this is in New York, so you have to have that in there. But the court was correct that it's finding, but I think the simpler analysis here is under the Liberty case is that the excess coverage was simply not triggered under these circumstances.
Thank you.
There are no questions. I'll rest. Thank you.
Mr. DiStefano?
Thank you, Your Honor. So what I heard was Global does not have the benefit of the excess policy, that the excess policies are not triggered. Well, the reason that they're not triggered is because they purposely omitted a contractual indemnity claim out of the complaint. And that would have triggered coverage under those policies for Global as well. So the fact that the coverage was not triggered is no doing of Global's, it's of Hunter Roberts, the third-party plaintiffs here. So when we look at that, though, you know, what counsel said was that the Liberty decision is this court's decision that says that, well, an excess carrier, there is no anti-subrogation, but that's contrary to Jefferson. Jefferson very clearly says on page 374, 92 New York 2nd, page 374, that Jefferson, the excess carrier, as subrogee should be prohibited from recovering under the other policy in its capacity as an insurer for Continental. So the court recognized that there was anti-subrogation even for an excess carrier. The court then went on to say, however, the excess carrier was still allowed to recover from another primary carrier, but on a priority of coverage basis. The priority of coverage analysis here is as between Hunter Roberts. It's what Hunter Roberts is going to have to pay and what insurers have to respond on behalf of Hunter Roberts. So we have the primary carrier in the CSIP tower, but what counsel references in his brief is that there's another insurance carrier, Axis. Axis covers a subcontractor named Allran. Allran is not covered under the CSIP because Allran provided electrical work for the project and therefore was not an enrolled contractor. So if Hunter Roberts wants to make the argument that Axis should be primary to Hunter Roberts excess insurance, that's fine. That's the priority coverage of coverage that's consistent with Jefferson. But to say that you're allowed to go after another contractor just because you're an excess carrier, that's not what Jefferson says. And the Second Circuit said it in Ohio Casualty versus Transcontinental, and the district court said it in an Ace American versus American Guarantee, both of which are cited in our briefs, that challenge the thinking that might have led to Liberty. And for those reasons, we do ask the court, especially considering that all of your honors are new members of the court post the Liberty decision, that you can have a chance to take a look at this and reconsider what the holding was there. The last point that I want to touch on behalf of on the issue of notice is just we've all been around the block. None of us are doing this, for the first time. The letter was clearly written to get the excess carrier to come to the table to mediate the case. It even says that there's an opportunity to mediate the case at that point, and they wanted the excess carrier there. The excess carrier, in turn, wanted the employer's liability carrier to come to the mediation table. And how do we do that? We do that by commencing a third-party action for common law indemnification. So that's all part and parcel of the process. There's no shortcoming in that notice letter. The letter was just the first step to try to bring the carrier to mediation. And it was on behalf of Global. This court's decision in E.E. Cruz very clearly says that as long as you see to it, and 3428.3 says as long as the notice is given by or on behalf of the insured, that constitutes sufficient notice under the policy, triggering the responsibility of the carrier to disclaim under 3420D. Unless the court has any other questions, I'll rest.
Thank you. Thank you for very good arguments. This is the last case of the afternoon, and it concludes argument for today. So thank you very much. Court is adjourned.
Have a nice week.
Thank you.
Thank you. You too.